marks were consistent with restraints being used, in other words, with Sara being tied up. Many of these injuries had tramline markings, which show that she had been beaten with an elongated object. You, Irfan Sharif, have admitted to beating Sara on a number of occasions with a metal pole, part of a high chair. The pole was found at the property after Sara's death. You also admitted to beating Sara with a cricket bat, which was also found at the property. At one stage you admitted to doing this multiple times, but then you changed your evidence, would only admit to doing so once. I have no doubt that in fact this was a regular occurrence, at least towards the end. You also admitted to hitting her on the head with a mobile phone. In addition to the 71 fresh injuries, the medical experts found a total of 25 separate fractures to the bones in Sara's body. These included a fractured collarbone, 2 fractured shoulder blades, fractured ribs, a fractured humerus, 11 separate fractures to her spinal column, and fractures to bones in both of her hands. The medical evidence stated that many of these injuries were highly unusual in a child. They went beyond what would be seen in sporting injuries and were of a severity that is rare even in road traffic accidents. They would have required multiple episodes of violence, each involving a substantial degree of force. These fractures were dated variously between 8 weeks before death and 2 weeks or so before death. This is not a case of a single episode of maltreatment, therefore. This poor child was battered with great force again and again. Some of the injuries require special mention because they demonstrate the almost unbelievable torture to which Sara was subjected in the last weeks of her life. The medical experts identified a fracture in the hyoid bone in Sara's neck. This is a very unusual injury and was the result of very vigorous and energetic manual strangulation, quite possibly on more than one different occasion. Sara sustained a serious brain injury a few days before she died as a result of a blow to her head. I have no doubt that you, Irfan Sharif, were responsible for these injuries. In addition, she had 2 open burn wounds on her buttocks. These were in the shape of the sole plate of an iron and matched the iron that was found in the house. These wounds had undoubtedly been caused by Sara's buttocks being pressed for several seconds against the hot plate of the iron, no doubt as a punishment. This would have required 2 people to carry out, one to hold Sara down and the other to press Sara against the iron. I am sure that you, Irfan Sharif, and you, Benash Batul, jointly inflicted this injury. One of the most disturbing features of this whole case is that the burns expert, Dr. Martin, said that this injury was sustained at least 2 weeks and more likely 2 to 6 weeks before death. He said that it would have been very painful. So, Sara had this terrible wound in her buttocks for a number of weeks before she died, but nobody had properly treated it or sought medical help for her. Had she lived, it would have caused permanent disfigurement. In addition, when she died, Sara had open burn wounds on the bones of the inside of each ankle. The only possible explanation for this, as is made clear by the medical evidence, is that Sara's ankles were tied and then either her feet were wrapped around a hot pipe or, more likely, boiling water was poured on her ankles. Once again, the wounds had not been treated and no medical help had been sought for Sara. The post-mortem investigation showed that Sara had 6 bite marks on her body. 5 of them were on her left arm and 1 was on the inside of her left thigh. The marks were made by an adult. You, Irfan Sharif and Faisal Malik, and Sara's older brother, each provided teeth impressions and each was excluded from being responsible for the tooth marks. You, Benash Batul, declined to give a tooth impression, and the only possible inference is that it was you who made these bite marks. Though the bite marks were not in themselves fatal injuries, the fact that you were prepared to assault Sara in this way provides an insight into the extent to which you were complicit in and comfortable with the abuse that Sara was suffering. But the medical and forensic evidence does not stop there. It is absolutely clear that in the last few weeks of her life, Sara was tied up. She was trussed up with masking tape and with skipping rope. Even worse, she was hooded. Plastic bags were put over her head, which were then held in place with masking tape, and a hole was ripped in the plastic bag through which she could breathe. Sara's DNA and hair were found on the masking tape and in one of the hoods. This treatment of a 10-year-old child is nothing short of gruesome. It is hard to imagine how terrifying it must have been for Sara, especially as the treatment was at the hands of her own parents. It gets worse. When the bins at the house were examined after Sara's death, the police found a soiled nappy wrapped around Sara's leggings. It is clear that you, Irfan Sharif and Benash Batul were putting Sara in pull-up nappies because she was unable to go to the toilet while she was trussed up. There was medical evidence that you would then let her stew in her own urine and faeces. Dr. Martin said that the injuries to Sara's ankles appeared to have been made worse by the fact that her ankles had been in contact with urine and faeces. This also means that the restraints were so tight that Sara's feet and ankles were pulled up so that they were in contact with her bottom. I have no doubt, in light of the evidence, that Sara will have been left trussed up for considerable periods of time, including when Irfan Sharif was out of the house, when Benash Batul and Faisal Malik were the only adults in the house. I have no doubt, therefore, that you, Irfan Sharif and Benash Batul, were jointly responsible for tying Sara up in this way, though I am sure that the idea would have been Irfan Sharif's. The medical evidence also shows that at the time of death, Sara was underweight and undernourished. The pathologist who carried out Sara's post-mortem examination, Dr. Carey, described the cause of Sara's death as being complications arising from multiple injuries and neglect. He said that the cause of death was not specific to a single injury or incident, but that the injury she had suffered cumulatively caused Sara's death. I have no doubt that Dr. Carey is right about this. I therefore reject the contention put forward at trial by the defence teams that Sara's death was solely caused by the brain injury that she suffered a few days before her death. That may well have been the last straw, but the constellation of injuries that Sara suffered over many weeks each made a significant contribution to Sara's death. This includes the burns to which you, Benash Batul, directly contributed. I now come on to the events on the evening of Sara's death. It is clear that at least partially as a result of the brain injury, Sara suffered a decline in the few days before she died. In the early evening of Tuesday the 8th of August, you, Benash Batul, saw that Sara was acting as if she was very unwell. You were worried and telephoned Irfan Sharif to come home. You, Irfan Sharif, assumed that Sara was acting up and faking illness. You did come home, but you were in no particular hurry. You stopped on the way to shop to buy some vapes. You admit that when you came home and found Sara floppy in Benash Batul's arms, you did not seek medical help for her. You did not comfort her. Instead, incredibly, you took up the metal pole and beat Sara vigorously on her abdomen to punish her for pretending to be ill. A few moments later, Sara died. The marks of that final beating were on Sara's body when it was found. You, Faisal Malik, were in the house, though probably not in the same room, when Sara died. The steps that the three of you took immediately after Sara's death were quite extraordinary. You did not call the police or an ambulance. Instead, you immediately sprang into action to protect yourselves by taking steps to flee to Pakistan with a view to abandoning Sara's body in the house. Within less than an hour of Sara's death, you were on the phone to a travel agent to arrange for flights to Pakistan for the rest of the family. The jury were played extracts from the call that you, Benash Batul, made to the travel agent, and you can be heard speaking coolly and calmly, as if you did not have a care in the world. You, Irfan Sharif, can be heard urging her to book an earlier flight. This was within minutes of murdering your daughter. The other children can be heard playing in the background. In the event the first attempt to book flights was unsuccessful and a second booking had to be made using Faisal Malik's credit card. Then you took steps to cover up what you had done as best you could. I have no doubt that all of you were engaged in this. Sara's body was washed, put in clean clothes and placed in a bed. The leggings, nappy, masking tape and hoods were put in bins. The metal pole was hidden away in an outbuilding. I have no doubt that you, Faisal Malik, were involved in this because your McDonald's uniform was found partly in and partly next to the bins, alongside the other items. Part of the uniform was soaking wet. You, Irfan Sharif, removed the Ring doorbell to hide any video evidence. There is some evidence to suggest that a pressure washer may have been used to clean Sara's body in the backyard of the house, but I cannot be sure of this. You, Irfan Sharif, left a note on Sara's body saying, "Whoever sees this note, it's me, Irfan Sharif, who killed my daughter by beating. I am running away because I'm scared, but I promise that I will hand over myself and take punishment." Most of this was true, but the promise was not, as you've done everything you could since the date of Sara's death to avoid punishment for your crime. The following morning, the three of you took all of the remaining children and drove to Heathrow Airport. You stopped on the way, Benash Batul and Irfan Sharif, to withdraw substantial sums of money in cash from your bank accounts. You then flew to Pakistan. You had no concerns for your other children. You took them away from their friends and relatives in England and the only place they'd ever lived because you were seeking to escape justice. You have taken no steps to assist in their return to the UK and they are still in Pakistan. The twins have been deprived of the specialist educational support that was arranged for them in the UK. Upon your arrival at Islamabad, you, Irfan Sharif, rang Surrey Police. You were tearful. You told the police dispatcher that you had killed your daughter and that her body could be found at the house in Horsell. You said, "I did legally punish my daughter and she died." Even then you were trying to minimise what you had done. You said that you intended to hand yourself in, but you did not tell the police dispatcher where you were. You deliberately gave the impression that you were in the UK. You lied and said that you were calling from your son's car. You all then went into hiding in Pakistan. There is no extradition treaty between the UK and Pakistan. Nonetheless, the Pakistani authorities started looking for you. On the 6th of September, you, Benash Batul and Irfan Sharif, took part in a bizarre video press statement in which you referred only briefly to Sara's death, saying that it was an incident, and then spent the rest of the time complaining about the pressure that the Pakistani authorities were putting on Irfan Sharif's family. Eventually, on the 13th of September 2023, the three of you flew back to the UK. Though you returned voluntarily, I am satisfied that none of you did so because you decided to own up to what you did. Rather, you left because Irfan Sharif's family instructed you to do so as a result of the heat that you were bringing down upon the wider family. You each intended to brazen it out. None of you answered any questions in police interview. I now come on to say something about Sara. Photographs of her have been widely published. She was a beautiful little girl, somewhat small for her age. She was full of personality. She adored her baby brother and cared for him lovingly. Her mother, Olga Domin, said that Sara was always smiling and had her own unique character. A teaching assistant at her primary school said, Sara was a bubbly, confident, chatty and engaging child. She would sometimes approach me and do a dance, sing something or put on a show. She was always happy in school and you always knew when she was in the class. She had a spark. She was a little feisty, and if she had an opinion, she would want to voice it and wasn't afraid to answer back. It is clear that Sara stood up for herself and remained positive and cheerful in the most terrible circumstances. She was a very courageous little girl with an unquenchable spirit. She loved to sing and dance. The jury was shown a video of Sara dancing in front of the TV a few days before she died. It is clear that by this stage her mobility was impaired, but despite everything, she smiled at the camera. Amongst the most heartbreaking pieces of evidence in this case were a short story that Sara wrote, which described you, Beinash Batul, as a queen who is beautiful and young. A birthday card in which she said, "Happy birthday, Dad, I love you so much," and a letter that she wrote to you, Irfan Sharif and Beinash Batul, in which she apologised for answering back and said, "Please forgive me, I am so sorry." The reality was that abuse, which for anyone else would be exceptional, had become normalised for this little girl. She had known nothing else for much of her life. You, Irfan Sharif and Beinash Batul, had persuaded her that she deserved the treatment that you meted out to her. A moving victim impact statement was read to the court from Sara's mother, Olga Domin. She finds it hard to understand how anyone would behave in such a way towards a small child. Ms. Domin has suffered greatly as a result of Sara's death, which has had a damaging impact upon her mental health. She had the small consolation that Sara's body was returned to her for the funeral in Poland. The events in this case, and in particular the fact that Sara's school had raised safeguarding concerns, and the fact that Irfan Sharif was previously on the radar of various authorities as an alleged perpetrator of domestic abuse, inevitably raised questions about whether more could have been done to prevent the tragic consequences in this case. However, it is not my role to express an opinion on this matter, and in any event, I do not have sufficient information to do so. That is not the purpose of the sentencing exercise. The primary responsibility for the death of Sara rests squarely with the three of you who are before me for sentencing. I will, however, make one comment. This is that this case brings into sharp relief the dangers of unsupervised homeschooling of vulnerable children. When they felt they needed to, you, Irfan Sharif and Beinash Batul, were able to hide the abuse that Sara was suffering by the simple expedient of announcing that she was to be homeschooled. Of course, there are many cases in which parents take their children out of school for periods of homeschooling for good reasons and with the best of intentions. But this case starkly illustrates the dangers. It is a matter of concern that parents who are abusing or who have malign intent towards their children appear to be able to homeschool more or less at will and without supervision. I now move on to the matters that I have taken into account for sentencing each of you. I will start with you, Irfan Sharif. As I have said, the only sentence that I can pass is a sentence of life imprisonment, but I must also set a minimum term. The first step is to identify the appropriate starting point. Your offending does not come within the class of offending for which a whole life order would be appropriate. The next question is whether the starting point for the minimum term should be 30 years. This is the starting point where the court considers that the seriousness of the offence is particularly high. Schedule 21 to the Sentencing Act 2020 gives examples of cases that would normally justify a 30-year starting point. Your offending does not come within any of the specific examples set out under this category in Schedule 21. These include murders involving sexual and sadistic conduct. However, the list in paragraph 3 of Schedule 21 of examples of cases that justify a 30-year starting point is not exhaustive. The way that you treated Sara, culminating in her murder, means that your conduct was of such a seriousness as to warrant a 30-year starting point, even if the word sadistic is not precisely apt to describe it. It bears comparison with the other types of murder set out in Schedule 21, paragraph 3, which justify a 30-year starting point. You plainly derived grim satisfaction from your campaign of violence against Sara. The starting point, therefore, is 30 years. However, the starting point is not the end point. I must also take into account the aggravating factors and, if and to the extent that there are any, the mitigating factors in your case. I say immediately that consideration of these factors will result in a substantial uplift from the starting point. Beginning with the aggravating factors, I will start with those that are specifically referred to in Schedule 21. In my judgment, these are they. First, your victim was particularly vulnerable due to her age. Sara was only 10 years old when she died and was 6 or 7 when your campaign of violence began. Second, the mental and physical suffering inflicted on the victim before death. This was extreme. I've already referred to the injuries that were inflicted on Sara, mainly by you. The assaults went on for around 4 years. They were accompanied by other acts of cruelty which meant that Sara must have been in a constant state of terror. You treated her as a skivvy. You took her out of school to conceal what you had done and then made no effort to educate her. The stress caused by your treatment meant that the poor child was vomiting and soiling herself, only to find that this provoked further punishment by you. In the last few weeks, Sara was tied up, was even hooded, by a grotesque combination of parcel tape, rope and a plastic bag. She was not even allowed to go to the toilet, but was put in pull-up nappies and was left to wallow in her own urine and faeces. The torture got worse. She was burned with an iron and boiling water was poured on her ankles. Third, the abuse of a position of trust. The ill treatment took place in Sara's own home. You were her father. You should have been her protector. It is hard to imagine a more serious breach of trust. I should add that I bear in mind the overlap between this aggravating factor and the aggravating factor relating to vulnerability due to age. There are other non-statutory aggravating factors. They are these. Fourth, I have no doubt that you singled out Sara amongst your children for harsh treatment because she was a girl and because she was not a child of your current marriage. Also, because she was prepared to stand up to you. Fifth, you used weapons, including a cricket bat, a metal pole, a hot iron and boiling water. Sixth, you also used restraints, mainly consisting of packing tape and hoods made out of plastic bags. Seventh, the assaults took place in front of and or within the hearing of the other children in the family and will have had a brutalising effect upon them. There was a suggestion during the trial that you may have recruited your oldest son to assist with the torture of Sara, but I cannot be satisfied that this happened. Nevertheless, it is clear that your oldest son was encouraged to bully Sara because you made clear to him that she was inferior to him. Eighth, when you came home on the 8th of August 2023 and found Sara very close to death, you did not call an ambulance or seek medical help. Your first reaction was to beat her with a metal rod for causing trouble. She was still conscious. This means that the last thing that Sara felt before she died will have been her own father beating her for supposedly faking injury. Ninth, as soon as you realised that you had murdered Sara, you fled abroad. I do not accept that when you did so, you genuinely intended to return and face the music. You went into hiding in Pakistan and would still be there if your family had not pressurised you to return. When you returned, you denied everything until 6 days into your evidence at trial. 10th, you disposed of evidence linking you to the crimes by getting rid of the mobile phones belonging to the 3 adults and by removing the Ring doorbell from the front of the house. 11th, in your attempt to escape, you uprooted your other children and took them to Pakistan, knowing that the twins have special needs which were being addressed by special educational provision in the United Kingdom. 12th, it is a major aggravating factor that in the period leading up to trial and for the first 6 days or so of your evidence, you tried to place the blame entirely on Benash Batul for acts that you knew very well that you had done or had mostly done. 13th, I am satisfied that you assaulted former partners and a partner's child and had behaved in a controlling or coercive manner towards them, though you have no convictions for this. You have a history of preying on vulnerable women, including doing so in order to obtain permanent residence in this country. And finally, you have shown no real remorse. Right to the end of the trial, your main objective was to evade liability for your crimes. You are suffused with self-pity. You have one previous conviction which is of no relevance for present purposes. I have borne in mind that some of the aggravating features in this case also contributed to the conclusion that the 30-year starting point was appropriate, and so I have been careful to avoid double counting. This applies in particular to the mental and physical suffering that was caused before Sara's death. Nonetheless, the degree of mental and physical suffering that you caused to Sara was, in my view, so extreme as to amount to an aggravating factor in this case, and, taken together with the other aggravating factors, means that a sentence of 30 years would not reflect the gravity of your offending. There is very little indeed by way of mitigation. You were 42 years old when Sara died. You are an intelligent, educated man. There has been no suggestion that you were suffering from any mental illness. I accept that you did not intend to kill Sara, but this is scant mitigation in these circumstances. You fully intended to hurt her, and to hurt her badly, and you did not care what the consequences for her would be. You intended that she would have a life filled with pain and misery. I also accept that Sara's murder was not premeditated, but for the reasons just mentioned, this is of little or no value as mitigation. Benash Batul. You too have been found guilty of the murder of Sara Sharif. I have described the nature of your participation earlier in these sentencing remarks. I sentenced you on the basis that your involvement in the years leading up to Sara's death consisted mainly, though not entirely, of encouraging and assisting Irfan Sharif in many of his assaults upon Sara. Indeed, during the early stages of the ill treatment, you tried to talk Irfan Sharif out of assaulting Sara. Nevertheless, it is clear that you valued Sara less than your other children because she was a female child who was not your natural child. You would call Irfan Sharif home when Sara was naughty, knowing and intending that he would assault her. You knew that the treatment that Sara was suffering was wrong, but, as I have said, you were prepared to sacrifice Sara because you did not really care very much about her and were frightened of losing your own children if the scale of the abuse became known to the authorities. However, you also took an active part in some of the maltreatment of Sara towards the end of her life. It was you who bit her on the arm and on the inner thigh not long before she died. These were not affectionate nibbles, these were bites. Also, I can be sure that you took part in the tying up and hooding of Sara. This was not the work of one individual, and Sara was tied up even when Irfan Sharif was not in the house. Still further, I have no doubt that you were present at and involved in the burning of Sara with an iron, which led to the terrible burns on her buttocks. This was a two-person job, one to hold Sara and one to press the iron onto her body. You did this despite knowing that the treatment was wrong. It is clear that you were sincere when you expressed your horror and concern in the early stages about the way that Irfan Sharif treated Sara, but you did next to nothing about it, and you became used to it and complicit in it. The calm, unruffled and chilling way in which you acted in the minutes after Sara died showed how unsurprised and unconcerned you were that the ill treatment had resulted in her death. As for the starting point for the minimum sentence, your conduct was of such seriousness as to warrant a 30-year starting point. You willingly encouraged or assisted the torture of this child for several years, and you continued to encourage and assist, and sometimes participated in it, whilst it became ever more extreme. As with Irfan Sharif, the starting point will not be the end point. The aggravating features are these. First, Sara was particularly vulnerable due to her age and her position within the family. Second, the extreme nature of the mental and physical suffering endured by Sara, though I bear in mind the need to avoid double counting. Third, the abuse of a position of trust. You were her stepmother and the main carer in the household. The ill treatment took place at Sara's home. You could, at an early stage, have put a stop to the hideous ill treatment of Sara by her father, and later by you, which you knew full well to be wrong. Once again, I bear in mind the overlap between this aggravating factor and the first aggravating factor, namely Sara's particular vulnerability. Fourth, Sara was singled out by you for ill treatment as a female child who had a different mother. Fifth, the use of weapons, including the use of an iron in which you were directly involved. Sixth, the use of restraints, which were used at times when you were the adult in charge of the house, as well as at times when Irfan Sharif was also in the house. Seventh, the assaults took place within the sight and hearing of the other children. Eighth, you took part with others in the deliberate concealment and covering up of the maltreatment which led eventually to Sara's murder. When she was alive, you connived in the use of the hijab, dark glasses, makeup and homeschooling to conceal the injuries suffered by Sara. Ninth, when you realised that Sara was dangerously ill, you did not call an ambulance, but you summoned Irfan Sharif home, knowing that he would not have Sara's best interests at heart. 10th, you flew to Pakistan alongside Irfan Sharif and Faisal Malik in an attempt to protect Irfan Sharif from capture and to evade responsibility for your own offending. In so doing, you abandoned Sara's body. As with Irfan Sharif, I am sure that the only reason that you returned to the UK was because Irfan Sharif's family pressurised you to do so. In effect, you were given no choice. 11th, you participated in the disposal of evidence, namely the mobile phones. It was not due to you that the WhatsApp messages were recovered. These were recovered from your sister's phones. 12th, you uprooted your other children and stepchild from their home and their life to facilitate your escape, thereby depriving your children with disabilities of the support that was being provided to them. And 13th, notwithstanding what has been said on your behalf today, you have shown no credible remorse. Inflicting some horrible injuries on Sara, in the main your role was the secondary one of assisting and encouraging Irfan Sharif in his actions. 2. Unlike your husband, you did display some very occasional acts of kindness towards Sara. You'd sometimes put cream on her injuries, and you would sometimes buy her nice clothes or treat her well. On the whole, however, she was treated by you as the family's servant, despite her very young age. 3. You were in a coercive and controlling relationship. You were vulnerable when you first met. He was considerably older. You were under cultural and family pressure to obey your husband and to follow his lead. I have no doubt that you feared Irfan Sharif and felt trapped into staying, especially as your father had disowned you and your family were encouraging you to stay with him, regardless of how badly he treated you and the children. You were yourself the occasional victim of abuse by Irfan Sharif. There is a reference in the WhatsApp messages, but only one, to Irfan Sharif hitting you. 4. You were under a great deal of strain because you were essentially the sole carer for 6 children in a flat and then a house, which were each much too small, and you had the great additional stress of having to look after the twins with their extremely challenging behaviour. 5th, I also accept that you had a difficult, strict and religious upbringing. Indeed, you'd been held captive by family members for some days, some years previously, because they considered that a previous relationship had brought shame on the family. You had been disowned and cut loose by your father because he disapproved of your lifestyle and a previous partner. You were in contact with 2 of your sisters and your mother, although Irfan Sharif limited this contact. It is also true that your family did not encourage you to seek assistance for Sara, and sometimes encouraged you in the view that both you and she should put up with Irfan Sharif's treatment. 6, you had a medical history of depression. And 7, you have a previous conviction for theft and fraud by false representation, but these are not relevant for present purposes. You are of effective good character. However, the impact of much of this mitigation is limited. Whatever your personal predicament and personal circumstances, you should have taken steps to stop this torture of a small child, instead of encouraging and assisting and sometimes participating in acts of extreme cruelty over a long period, knowing that they were very wrong. You are a strong-willed adult, aged 29 at the time of Sara's death, and you are not so cowed by Irfan Sharif's treatment of you that you were effectively prevented from speaking up. You could think for yourself, as is shown by the fact that you did, in 2022, seek advice from a solicitor about a divorce and custody of the children. You took a positive decision not to seek help for Sara because you did not want to lose your other children, but this cannot possibly amount to significant mitigation. You just did not care about Sara in the same way you cared about the other children. You did not intend to kill Sara, and her killing was not premeditated by you, but, as with Irfan Sharif, this is scant mitigation. You returned voluntarily to the United Kingdom in September 2023, but, as I have said, this was the result of pressure from Irfan Sharif's family. You have lost contact with your other children, and this is hard for any mother, but you chose to take them to Pakistan, knowing that efforts would be made to ensure that they did not return to the UK. Faisal Malik. You've been acquitted by the jury of murder, but you've been found guilty of causing or allowing the death of a child. The Sentencing Council's guidelines for this offence draw no distinction between causing or allowing the death of a child. However, I sentence you on the basis that you did not yourself cause Sara's death, but rather your offending consisted of failing to take reasonable steps to protect Sara from the risk of serious physical harm being caused to her by the unlawful acts of Irfan Sharif and Benash Batul. I cannot be sure that you played any active part in the ill treatment of Sara. Indeed, I do not believe that you did. There was no evidence at trial that you had done so. I have summarised the relevant facts earlier in these sentencing remarks. You came into the family home in December 2022, some 8 months before Sara's death. You were not present when the campaign of ill treatment began. Once you took up residence in the family home, you spent much of your time there, especially during the university vacation that began in May 2023. This was the period of the worst of the torture that Sara endured. You cannot fail to have been aware of much of the terrible ill treatment to which Sara was being regularly subjected, including beatings, burnings, and the tying up and hooding of Sara with tape and plastic bags. You stood by and did nothing. I have no doubt that your offending falls within category 1A, very high culpability in the relevant sentencing guideline. Very high culpability is indicated by the extreme character of one or more of the culpability B factors and or by the presence of a combination of culpability B factors. One of the culpability B factors is failure to take any steps to protect the victim from offences in which other specific culpability B factors are present. This failure was extreme. Your failure was a failure to protect Sara from offences in which almost every single one of the other specific culpability B factors was present. You failed to protect Sara from prolonged and multiple incidents of serious cruelty and serious neglect. You failed to protect her from gratuitous degradation consisting of the restraints and hooding. You failed to protect her from the use of very significant force involving the use of weapons, namely the cricket bat, the pole, the iron and hot water. You took absolutely no steps to protect Sara. The starting point for a category 1A offence is 14 years custody, and the range is from 12 to 18 years custody. In your case, the aggravating factors are these. First, the prolonged and exceptional suffering endured by Sara prior to her death. Once again, I bear in mind the need to avoid double counting. Second, the offences were committed in the presence of other children. Third, failure to seek medical help. Fourth, you paid for the flights to Pakistan and helped the family to flee, fleeing yourself. Fifth, you disposed of important evidence in the form of your mobile phone. And sixth, you have shown no remorse. The mitigation is very limited in your case. You were 28 years old at the time of Sara's death. You were a graduate student. Although you had only recently arrived in the UK and you were living in your brother's home, there was nothing to stop you from notifying the police of Sara's treatment. You hardly knew Irfan Sharif, and the respect you may have thought was due to your older brother was no excuse to failing to call him and his wife out in their behaviour. There is no suggestion that he bullied or threatened you. You knew the difference between right and wrong. You were not forced to stand by while Sara was treated in this way. I bear in mind that you are of previous good character. You returned voluntarily to the United Kingdom in September 2023, but as I have said, this was not done out of a desire to own up to your offending. Rather, it was the result of pressure from your family in Pakistan. I also bear in mind that much of the abuse of Sara took place before you arrived in the UK. I must consider whether you meet the criteria for dangerousness as laid down in the Sentencing Act. If so, I would have to consider whether to impose a life sentence or an extended sentence of imprisonment upon you. An offender is dangerousness if there is a significant risk to members of the public of serious harm occasioned by the commission by the offender of further specified offences as defined. I have considered this matter carefully. Notwithstanding the truly horrific nature of the treatment suffered by Sara, I have concluded that you do not meet the criteria for dangerousness. There is nothing in your earlier life to suggest that you're a dangerous offender. You are not the prime mover in the ill treatment of Sara. As I have said, there was no evidence that you took any active part in the torture of Sara. Your role in these horrific events was limited to standing by and failing to take any action to prevent them. I now come to the sentences. Irfan Sharif, Banesh Batul and Faisal Malik, stand up. Irfan Sharif, for the murder of Sara Sharif, I sentence you to imprisonment for life. Taking account of all the relevant circumstances and the aggravating mitigating factors that I have set out, the minimum term will be 40 years. Benash Batul, for the murder of Sara Sharif, I sentence you to imprisonment for life. Taking account of all the relevant circumstances and the aggravating and mitigating factors that I have set out, the minimum term will be 33 years, less the time that you have spent on remand. For the offence of causing or allowing the death of Sara Sharif, I sentence you to imprisonment for 16 years, less the time that you have served on remand. You will serve up to 2/3 of your sentence in custody. You will serve the remainder on licence. You must keep the terms of your licence and commit no further offence, or you will be liable to be recalled, and you may then serve the rest of your sentence in custody. You may take them down.